This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why the Fifth Amendment does not apply to corporations or non-human entities, and why a criminal investigation of insurance fraud without an indictment or arrest are not grounds for the stay of a civil action. Defendant Kith Furniture, LLC, moved to stay the proceedings brought by Liberty Mutual in Liberty Mutual versus Kith Furniture, LLC, a July 1, 2024 decision of the United States District Court for the Northern District of Alabama, as the district court resolved the dispute over when and whether the Liberty Mutual suit should be stayed. Kith's furniture plant and inventory were allegedly damaged in a tornado. While investigating Kith's insurance claim, Plaintiff Liberty Mutual learned information that called Kith's claim into question and warranted further investigation. Kith insisted that Liberty continue making payments under the policy during the pendency of this investigation. Liberty sued, seeking a declaration that it need not continue making payments until it concludes its investigation. Simultaneously, the Alabama Department of Insurance Fraud Bureau opened an investigation into Kith's insurance claim. Liberty amended its complaint to add a new claim alleging fraud, and Liberty alleged that Kith's employees intentionally damaged almost $500,000 of furniture that Kith could no longer sell to make it look like it had been damaged in the tornado. Kith asked the court to stay all proceedings in the action pending the Alabama Department of Insurance's criminal investigation. Kith contended that it will be substantially prejudiced by having to defend itself in this action while simultaneously facing a parallel criminal investigation. Liberty countered that if this court stays this action, Liberty will be substantially prejudiced by the very real risk that evidence would be lost and memories would fade. This case significantly overlaps the related criminal investigation because the Alabama Department of Insurance opened its criminal investigation on the very insurance claim at issue in the Liberty suit. Kith asserted that the investigation and this case involved the same legal theories and alleged conduct by Kith and are practically identical. Liberty dismissed Kith's assertions as entirely speculative. Emails exchanged between Liberty and a criminal investigation tend to corroborate Kith's assertions. But then Kith thinks it has Fifth Amendment rights, but the Fifth Amendment privilege against self-incrimination does not exist, nor does it extend to non-neutral, non-natural entities. Courts routinely hold parallel criminal proceedings and do not entitle corporate defendants to a stay of civil proceedings. And since there were no criminal proceedings, because Liberty's attempts to distinguish this case from those cited by Kith in support of its motion, one fact stands out. There are no pending or imminent criminal proceedings. The record does not indicate that anyone has been indicted, charged, or arrested for any crime related to this insurance dispute. The lack of pending or imminent criminal proceedings makes any potential avoidance of prejudice to Kith or any potential conservation of judicial resources by granting a stay entirely speculative. Liberty, on the other hand, faces potential prejudice from the delayed proceedings, and its argument that staying the case would be putting Liberty's civil action on the shelf to grow cold without the benefit of a criminal prosecution against Kith was supported by the district court. Although Alabama's ongoing investigation somewhat mitigates the risks that evidence will be lost and memories will fade, the current absence of any arrests or criminal charges failed to assure the court that Alabama's investigation will be sufficiently brief and exhaustive to shield Liberty from all prejudice. This factor weighed heavily in Liberty's favor, and therefore Defendant Kith Furniture's LLC's motion to stay proceedings was denied. In my opinion, Liberty found evidence of fraud and needed to move forward with its action before evidence became lost or forgotten. A criminal investigation without an arrest or an indictment is nothing more than that, an investigation. There is no reason for a stay of the civil action. My experience makes clear that state investigations into insurance fraud seldom result in an arrest or trial, while a civil action asserting fraud can be brought to trial quickly without the need of a criminal investigation, which has to prove the fraud beyond a reasonable doubt, while the civil action simply needs to prove its point beyond a preponderance of the evidence. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you can also subscribe to the videos on rumble.com and youtube.com. And if you do, please click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. And please also tell your friends and colleagues about this blog and the videos so that they too can subscribe. Thank you for your attention.